All right, this session is going to be on the Constitution of Innovation, and it was a great segue at the end, Gregor, leading us into discussions on sovereignty, because that's what we're going to talk about now in many ways. The idea of the Constitution of Innovation, and I'll give a little overview of it before we get into the discussion, but it came out of an event. It was very much inspired by the Draghi report. We ran an event called Implementing Draghi, supported by Ben and Booking, to try to push the ball forward. And coming out of that event, we had about 30 experts here in the EUI, and coming out of that was this manifesto. Do you like manifesto? No? What would you call it? Declaration. A declaration on the manifesto does have a historically bad ring to it, maybe. It's okay. It's dangerous. All right, so the declaration, the Constitution of Innovation came out of that, and then we've also started to work with some of the key proposals. And so for today's session, the idea is to use it as a framework to discuss the governance issues. So if you look at Draghi talks a lot specific issues on finance, specific issues on innovation and governance, but if you think about it, they're not really all parallel. If you don't solve the governance issues, it's hard to solve any other issues. So I think that's what came out of the discussion on implementing Draghi, was that the Constitution of Innovation should focus on the governance structures required to facilitate innovation and then prosperity from that. So today, I'm joined by a great group of panelists. So I'd like to introduce them. So first, I'd like to introduce Lorenzo Allio, who's a standing expert at the OECD and is the owner and founding partner of Allio Rodrigo Consulting. Welcome. Online today, we have Miguel Maduro, who's the Dean of the Católica Global School of Law and the founding Dean of the EUI School of Transnational Governance, and also is a current adjunct professor here at EUI. Welcome, Miguel. Can you hear me?
Yes, I can hear you. You can hear me too, I assume. Yes.
Perfect. Great. And then last but not least is Branislav Turcina, who's a policy officer at DG RTD, which focuses on innovation policy and access to finance at the European Commission. So what we're going to do today is I'm going to do a little overview of the Constitution of Innovation for those of you who haven't read it through. And then the panelists are going to comment on their thinking on EU governance, using this as a kind of template in general. And then we'll talk specifically about the 6 proposals very quickly. And then each of our panelists will discuss their areas of focus related to these proposals, and then we'll open up for questions. I hope that's good. When I say it, it's the illusion of democracy, right? It's good. Okay. So let me get going then. So the Constitution of Innovation, a New European Renaissance, was written by Luis Garicano, the professor at the London School of Economics and former member of European Parliament. Bengt Holmström, the Nobel laureate from Finland at MIT, and our own Nicolas Petit. So when we focus on, we start again with Draghi, right? So if you think about DCI's mission, just quickly, DCI's mission is to place innovation at the center of policy and regulation, and that includes policy making regarding competition and competitiveness. So we talked a lot about competition. We talked a bit about competition in relation to competitiveness. This is very much starting on the top, on competitiveness and prosperity, to try to start on the top level. And I think that was also how Emmanuel started to talk from the beginning of the conference as well. So if we look, we've seen these graphs before, the EU-US GDP per capita gap widened from 15% in 2002 to 30% in 2023. Italy's GDP per capita in 2023 was almost the same as in 2000, so no change in 23 years. A quarter century with no growth. So what does this mean? It means that Europe is getting poorer, America is getting richer, and so is China. This graph you've all seen. We just discussed this. We think that this should be made into wallpaper and put on every policymaker's bedroom. When they wake up in the morning, this is what they see. So no European company worth over 100 billion has been set up from scratch in the last 50 years, except one, the Swedish company Spotify now. In the same period, the US created 6 companies worth over $1 trillion. Only 4 of the world's top 50 tech companies are European. So this is a good reminder of the situation that's been created in a relatively short period of time. Jacques Delors, yesterday, Thibault, or is it Thibault over there, Schreppel, he was making fun of my French, weren't you? Nicola likes to give me French names to pronounce. This is part of our, we have lots of stories on this. He was a former commission president. He captured Europe's principle of action in a famous metaphor where he said that Europe is like a bicycle. It has to move forward. If it stops, it will fall over. This produces a constantly growing bureaucracy for its own sake, resulting in that we don't have an effective single market in Europe, but we do have effective regulation on the amount of fruit in marmalade. So this is a problem. So maybe the better analogy for the EU is a house. It's in need of renovation, not necessarily expansion. So in the Constitution of Innovation, the main mantra is less, better. This idea from Peter Drucker, one of my favorite quotes, there's nothing so useless as doing efficiently something that should not have never been done in the first place. This should also be on the wallpaper when you get up. So the challenge, and this is quote from Draghi, the challenge, if Europe cannot become more productive, we'll be forced to choose. We will not be able to become at once a leader in new technologies, a beacon of climate responsibility, and an independent player on the world stage. We will not be able to finance our own social model. We will have to scale back some, if not all, of our ambitions. This is an existential crisis. Existential crisis. So we have a window now. We have the issues with China pushing. We have the issues with Trump, with Putin. We have the Draghi report. So as they often say, a crisis is a terrible thing to waste. Maybe this brings Europe together. So this is what we hope to spur and to push forward with a coalition of the willing through the Constitution of Innovation. And so now I would like to I think you have your presentation coming next, Lorenzo. Maybe we start with you, Lorenzo. Yep.
Yes, good morning from my side as well. And thank you once more for the invitation. It's a pleasure being here. I'd like to start off with an apology to the authors, because I will not spend too much time in praising the declaration. This is why, because it finds me very much aligned with it. So it would be pleonastic. I found the declaration crisp. I found it well structured. Courageous at this moment. I think it's very important. But above all, it's a solid message that comes across. And just like to, or what I retained are the following keywords. Innovation is for prosperity and through private benefits or profits. There are no free lunches, so there are always trade-offs. Dynamism and creative destruction is not a threat. And then this line that I think resonates very much, which is regulation is confused often with progress and bureaucracy with integration. And that is where I would like to start my reflections from the topic of the conference, which is Quo Vadis, and see how or what can be done to really cherish regulation and turn it into an asset for innovation rather than a burden. And after all, the EU is a legal construct, and the declaration is not about deregulation. This is very important. So my my short remarks here, it's about what's in it for better regulation. Better regulation is very much a European jargon. The OECD talks about regulatory policy. You can also refer to it to good regulatory practices or good regulatory management. And again, if we consider the topic of the conference, Poiares, just a spoiler, I would not like to see the better regulation efforts and the structure that the European Commission, the EU institutions in general have set up as going to Rome and maybe be crucified like St. Peter. So hopefully that is not the direction that it's going, but I have some doubts. The starting point is that the current debate about better regulation is very much tilted into, let's get rid of those nasty compliance costs. And it's a matter of quantity of legislation, it's a matter of quantity of those burdens that hamper competitiveness. And in fact, what the European Commission, pushed by various forces, has done is to come out with the omnibus packages, as we all know. And point is that, yes, they might help saving some compliance requirements, but structurally, they are not there to cure this, or they might be at best cure the symptoms, but not treat the causes of what Europe is suffering from, which is, as we just said at the last part of the last panel, but in general, there is no inflow of capital to Europe. And the causes have not been really diagnosed correctly, in my view, and not even in the Draghi report. And this is what I'd like to focus on. Interestingly, and in my opinion, also a bit disappointingly, corporate business has not addressed the real causes either so far in their advocacy. And they are contented with going with sheer compliance cost savings. Take, for instance, reporting obligations. Yes, they are very burdensome. They are at the core of the first omnibus packages that we have seen. But what's interesting to note is that reporting obligations must be considered not as they used to be, which is just a way of signaling to financial, for instance, in accounting, to financial entities, the trustworthiness and reliability of businesses. Reporting obligations have turned into a policy instrument, for instance, for ESG purposes. So if that is the aim of introducing reporting obligations in law, then do a proper cost-benefit analysis of it. What is the actual benefit of all those costs, of all those, cost imposed? And that has not been fully taken on board. The assumption is that there must be some benefit because we are on the moral side of this story. So the benefits very often have been taken for granted or assumed to be there. So what is the distinctive feature that characterizes regulation in Europe? And I think that is where I would like to see one of the causes I was referring to, is that in Europe, more and more, but definitely as a default in the last few years, regulation is seen to steer change, to steer innovation instead of enabling it, instead of being one of the enabling framework conditions for investment. No, innovation is there because we know as regulators where it should go and how it should emerge. And this comes from a number of, let's say, points. The first one is that there is a preference for push factors, so demand side, there is a dirigist approach, entrepreneurial state as a keyword, mission-oriented, but this has some downside. the fact that this is not really the most fertile ground for dynamism, for technological neutrality, for creative destruction and the startups. It picks winners. And there is sheerly no sufficient know-how in the state, in the public sector, compared to the markets. So that is a big flaw, in my opinion. It comes also with the idea that regulation must eliminate risk from innovation by limiting technology. So you regulate the inputs of production processes rather than eliminating the risk by looking at the accepted level of safety. So regulating the outcomes. And this is something that you can see across several sectoral legislation. And here comes the discussion about hazard-based approach, about precautionary principle, about new, let's say, factors deciding how to market technologies, safe and sustainable by design, grouping, etc. We can give examples later on if you wish. And finally, this approach tends to neglect the existence of the negative and positive choices by investors. What do I mean with that? Investors, well, economic operators in general have to take negative decisions, discontinuing status quo technologies, abandoning or, let's say, mitigating current uses and operating processes because of regulatory requirements. Fine. But this dirigist approach implies that there is automatically a follow-up positive decision by investors to come in with alternative desired or desirable alternatives, which is innovation. Yet, in reality, these two decisions by economic operators are not automatically occurring. And this is lead to regrettable substitutions as well. So, very quickly, against this, what can the better regulation agenda do? Well, as far as we can see at the moment, the direction taken is not super promising in the sense that we observe that we're going some sort of discretionary approach to applying good regulatory principles and practices. The Commission latest consultation calls it about modernizing the approach. We have a nice set of tools and, let's say, arrangements, but now we want to go simplify by default, swifter decision, ad hoc, cherry-picking application. And then we have also this buzzword of sandboxing, which it's another way of saying derogation, because you have a legal framework, but you can actually carve out your space and try out and test your things outside what is the normal framework. And derogation is never conducive to systemic investments. And so I think that what instead should be done is to really invest more into understanding consequentialism. So to look into what are the responses of investors to the regulatory stimulus. So go a bit further than just compliance cost and see these dynamic impacts, diversions of allocation of resources, defensive R&D, capitalized development cost, time to market, stigmatization of technologies. Really look into unintended consequences, especially risk. So while addressing one risk, you might create another risk, and we can give examples to that. And finally, realizing that in a highly regulated economy, the marginal cost of reaching or capturing the next benefit is very, very costly. So if we want to reduce emission down to zero, it's really very costly. and it might be disproportionate. So that is something that needs to be integral part of the reasoning. And in order to have these, a few years ago, we were proposing the introduction and the application of what we call the innovation principle, which is not a legal solution. It's not like introducing in legal books the concept of innovation like we have the precautionary principle, but it's the mindset that allows considering always the impact of innovation when thinking new initiatives. With that, I would stop here, but we will have other rounds. Thanks.
Very good. So it's more, comma, better in some way. All right. Thanks a lot, Lorenzo. All right, let's go to you, Miguel, please.
Hi.
Hello.
Hello. Can you hear me?
We hear you well. Please go ahead
Okay.
when you're ready.
Yeah, I am. So thank you very much for the invitation. I'm sorry that I can't be there with you. I have a celebration of another constitution here in Portugal today, 50th anniversary of the Portuguese constitution. Maybe not such an innovative constitution, but still important to celebrate. And
it's good to celebrate democracy in this time.
Exactly. And we can celebrate it while we have it, at least. So first, I also want to say that I liked a lot it's not the declaration, not the manifesto, the declaration. I liked it a lot. There's a lot of things in it that I agree with, and I like particularly the fact that it's innovative, not only in name but in proposals. This said, I too disagree with the kind of driving theme that I actually don't think reflects what is in the proposal itself. That it is that what the union should do is to do less but better. First, I think that actually doesn't reflect what is in the proposal itself. There's a lot of things in the proposal that are not about doing less, but are about doing more. Better, yes, but doing more. I mean, uniform regulations instead of directors, establishing commercial courts, creating the optional 28th regime. Those are all things about doing more. So I understand the attractiveness of using the slogan as an overall, an encapsulating format for everything that you want to promote. But I actually don't think that you are arguing for doing less. And I actually don't think that's what the union should be doing, simply saying doing less. And in this, I agree very much with the previous presentation. It's not about doing less, it's about what we do and the quality of what the union does. So the first point that I wanted to make is that when we discuss this kind of issue, the declaration is, I think, very right on that. There are two opposing visions of the European Union in the past. One that was focused on the mostly promoting of market integration and therefore eliminating national regulatory barriers to that economic integration. And on the other hand, what the declaration describes as a defensive approach that is a focus on the idea of the Brussels effect and of using the regulatory power of the union as a kind of almost of a competitive tool. That if we are first regulating certain areas, then that becomes a competitive advantage for our companies. And there's been a tension between these two aspects in union. And the use of the regulatory, and what I think is important for us to take into account, particularly when we link it with that governance dimension that you mentioned, is that the focus on regulation that we have in the European Union is not so much a product of a choice between alternatives. It's to a large extent a consequence of the only thing that the union can do. So we have to understand that political background that is, to a large extent, contrary to other policy communities, and we can describe the European Union for the purposes of this as a policy community. While other policies communities, such as federal states, such as the US, have both the power of the purse and the power of regulation, the European Union only has the power of the regulation. And that has always created a bias toward regulation, because when something is claimed that is necessary for the Union to do or to promote or to achieve, the instrument that it has often is regulation. It doesn't have the instrument of financial incentives. The instrument of the Union budget is minimal, almost irrelevant in many respects. And that, I think, it's part of that bias. So I think it's very difficult for us to have a serious discussion about the extent to which the Union should regulate, and where should it regulate, and how should it regulate, if we don't correct that policy biases that comes from the imbalance between its power of the purse and its power of regulation. That's the first point. That's the first point that I wanted to make. And I will add to that even in the limited power of the purse that the Union has, it doesn't use it well. And that's perhaps because it's so limited, the Union ends up using it in a way that I think, and we can talk about that, it's not the best way. I know very well the EU structural funds and how they apply, and how the European Commission even uses those funds, and they are often the policies and the rules that guide them are not, in my view, the best ones. And the discussions that are taking place even at EU level on whether to centralize them are not the right discussions. Okay, it's basically there's a lot of discussion on the use of EU funds towards results orientation. The entire framework of incentives on which they've been established and that continue to apply are focused on outputs, not on outcomes. So that's the first point, and the first, I think, link with the governance dimension that we need to take into account in thinking about this. The second point I wanted to make is that the other underlying difficulty in this discourse, and is the difficulty whereby that the declaration also reflects, whereby we've had a lot of reports on on the problems the European Union faces, but then the actions are limited, or more often don't match what is actually necessary. Or when the Union acts, such as the description, for example, on the attempts of the 28th regime, it ended up having the opposite effect of what is intended. That has a lot to do with the nature of EU politics. And the difficulty, and it's the other challenge that I think we need to face seriously, and without us facing them, I don't think that we'll be able to have an appropriate regulatory approach in the EU, is that the same elements that create the need in many respects for the Union to regulate or regulate differently than it has done so in the past also makes it very difficult for that to be adopted. So what renders necessary a 28th regime is also what explains that if a 28th regime is adopted, it will tend very likely not to be effective at all. And that has to do with the nature of political fragmentation in the European Union and the extent to which that has then deep consequences on its policy choices. So I think we need to face that question on how we organize the political space of the European Union, because if we don't, then we will continue to have what we have now, that is often the political action that follows the need and the claims for better responses, including better regulatory responses, ends up making things worse instead of doing things better. And this leads me to the final overall starting point that I wanted to make. That is, I think we need to start a discussion on better regulation for the Union. And I like the idea of better regulation, but not that the Union has talked about for a long time, instead of less, by discussing what exactly should the European Union be doing. I mean, I know this sounds a very almost philosophical or existential question, and perhaps too broad to be effective, but I think that we are actually lacking that discussion at the European Union level. And I see three areas or three reasons for the Union to intervene. And those three reasons, in my view, should guide our understanding of its regulatory role. And the first one is when the Union either corrects externalities that exist between its member states' policies or promotes some common European goods. The second one is where the Union can increase the scale where that scale is rendered necessary. For example, because current geopolitical necessities on defense or what COVID demonstrated on health determined that we need a form of autonomy at European level, so-called strategic autonomy that requires scale that member states don't have. But it's something that cannot be done also at the global level effectively. So we need to determine what are the areas where scale is necessary and where the Union can give its member states that scale. It's also the matter of market integration, again, where that scale is necessary there. And that's the second fundamental aspect that should guide the Union action, where scale is necessary in the world we live today and where the Union can offer that scale, that dimension to the member states. And the third one is the regulation of transnational private powers, something I've worked on very much. The digital domain is one of them. Sports is a domain that very few people talk about, very relevant economically, very few people talk about it, and where the Union has a tradition through the court, but not through the regulator of acting, unfortunately. But that's also an area where the Union can be of clearly added value with respect to its member states. But again, it doesn't mean that the regulation needs to be the form that we have. For example, I don't think we need less regulation in the digital domain as such in absolute terms, but I do think that we need a different regulation than what we have in the digital terms. I think there are areas where the Union is not regulating, or even in some areas it doesn't need to adopt new rules, but could enforce much better the competition rules on digital tech companies, and is not doing it so. And on the other hand, it's over-regulating and imposing unnecessary burdens on digital companies that shouldn't do. So the question again is not one of less, it's one on the quality and the choices of regulatory choices that we have. And my main point is this one. Those choices need to take into account precisely those overarching areas where the Union can be of added value, and we need to discuss that, and we should have really an agreement and an understanding where the Union can be of added value to its member states. And second, we need to understand the political conditions and to work on the political conditions that will make it possible for the Union to regulate better, not being a question of less or more, but simply regulating better. Thank you.
All right. Thanks a lot, Miguel. So we have two no's on less and 2 yeses on better. I think that having spent half my life in the US and half in Europe, I have to say that only in America do people run for political office when they ask them, what are you going to do when you're there? I'm going to dismantle the government. I think it's only in the US where people, and then the people vote for those people, say, yeah, that's what we want, someone that goes in there and gets rid of the government. So it's an interesting discussion. So I know Branislav is going to go for less because that'll be less work he has to do at the commission. So I'm hoping for a positive yes, Branislav.
Yeah, actually, it's what I wanted to start with. That's listening and reading the Constitution for Innovation paper or declaration. I actually, for once, I was actually very optimistic because when I was reading it, of course, we all agree with the core issue. Europe lagging behind its main competitors. Draghi said it. There was just many papers, many arguments, or many ideas why this is happening. But why I'm optimistic is that I when I was reading the paper, I was thinking, and the suggestion in it, I was thinking, yeah, but a lot of it is actually currently being already done. So we have currently, as of December 2024, we have a second von der Leyen Commission, which by default is a competitiveness commission. That's competitiveness is really on top of the agenda of everything that the commission currently does. I think Draghi and others, they were really heard loud and clear in the corridors of the Berlaymont. So that gives me optimism that we are heading the right direction. And of course, I'm not an expert on everything commission, but what I would like to do is to look at the progress through the prism of startups and scale-ups, which is an area that I am working on. And why startups and scale-ups? Because they are an excellent example of what the commission does, but they are also a very interesting animal. So they are crucial for innovation. They are small companies that are almost by default innovative because they have to challenge the incumbents with a disruptive solution. So that they are really a huge driver of innovation everywhere, including in Europe. But because they are so small and because they have very big financing needs and very specific financing needs, they tend to, and they have also scale-up needs. So they are very often, very quickly need to become international. They need to grow across the borders in order to sustain themselves. So they are very often suffering more than the others from the imperfections of regulation or of markets that exist, and then that impinges on their ability to grow. And startups and scale-ups have become one of the core focuses of the current commission. We have, for the first time ever, a commissioner for startups and research innovation, our Commissioner Zaharieva. So it shows that the commission and the union is serious about supporting these types of companies and, by extension, also innovation, of course. And one of the first deliverables that in this area was done by the current commission was the last year's startup and scale-up strategy adopted by the commission in June, which is a really, I would say, crucial element in the future action, because first of all, it looked at what are the issues faced by startups currently in Europe, following a very extensive consultation of the startup community, of experts, of academia, of all the stakeholders somewhat involved, including the financial sector. And it identified basically 5 areas where startups are really suffering in Europe, or they are having considerable issues. And that is, first of all, accessing finance. Draghi said it, VC, much less than in the US. Accessing infrastructures and services, accessing talent is a problem, and then problems stemming from regulation and from regulatory burden, regulatory fragmentation. In reaction to that, the strategy put forward 26 actions to counter these issues, and these actions range from financial to policy to regulatory ones. And just to name 3 of them, out of which 2 of them I'll talk about later. But on the regulatory side, the 28 regime, important action that has been or is being delivered on. Another issue is defining the basic principles, or actions defining the basic principles on the establishment, operation, and follow-up of regulatory sandboxes. We can talk about later because it's a fascinating area. Or simplifying the rules on public procurement and making basically public procurement more innovation friendly. And by the way, linking to what Miguel said, at least these actions cover at least 2 of the sort of thing what you are doing, rules that Miguel mentioned. So for instance, when we talk about the 28 regime, this is really trying to correct the externalities that exist between the member states due to the fragmentation of the various corporate laws. So that's one. Or for instance, when we talk about increasing scale, that's the role of the public procurement. So thinking about public procurement as something that can increase the scale on the demand side, where you can basically find more money for innovation in the future. So these are just some examples of how basically the commission is really thinking how startups and, again, by extension, innovation first approach. And by the way, on the governance, that's also an interesting thing that Bo mentioned in the beginning. startup and scale up strategy, and what is behind it is also an excellent example of how Commission is changing its thinking when it comes to governance. So startup and scale up strategy was prepared by what is called the Startup and Scale Up Task Force, which was established within the Commission, and which basically encompasses people from different departments of the Commission, whether it's trade, competition, transport, whatnot. Everybody who is somehow marginally or less marginally related to startups, they brought them together into one room, and this was basically the group of people that worked on the strategy. And it's what our commissioner calls the whole government approach. And I think you know, or you have heard how the commission functions, right? So often commission is blamed for working in silos. And this is really the example where the commission is trying to break these silos and really come with the ideas together and create better policies through this approach. So there's also innovative approach towards the governance as well. So that's what I want to say about what the commission is doing now. But I had just two more reactions on some of the issues identified in the constitutional innovation. One of them is that, of course, well-functioning and integrated single market is super crucial for the functioning of startups and again, innovation in general. But you know, it's probably not the only one. So there are other policy areas that are also super important for a thriving innovative ecosystem and for thriving company ecosystem. And in this regard, I think we still should not forget the Europe's unique social model that you know, provides safety, security to its citizens. We know that actually having a safety net in terms of a well-functioning social security system is actually conducive for innovation, because it makes you take more risks, because you know, if you fail, you have the safety net in which you can fall into, and then you can restart again. So a great example, Danish flexicurity system that works in this way, and it's been proving as a sort of a state of the art how to do social security. And the other thing is obviously all the climate related policies. I mean, again, countless papers written on risks of climate change vis-a-vis the economic growth. So I think we need to also continue diversifying the policy making in the EU, tackling these other challenges, because then they have also direct or less direct, but still impact on economic growth. And finally, on the topic of regulation and regulating early or not, I mean, again, Europe is being blamed often to step into the regulatory area too early when it comes to new technologies. But it's also not always to the detriment of innovation. So again, there are many lawyers here. We know that, or we believe that legal certainty is a super important thing, and it is a super important thing for both economic operators in the area and the investors that invest, because then they have the certainty that what I'm investing into is going to be compliant also with tomorrow's regulation. So predictable rules by default are not they are not obstacles to innovation, quite the opposite. And they, of course, reduce investment risks, enable long-term planning, and increase trust among the various actors. And I mean, a good example to that is Europe regulating early is, for instance, area of drones, which was my previous work, where Europe was actually quite successful in being the world leader in being the first to regulate drones as a technology. And it's kind of a role model that is now being taken over by other countries as well in the world. So we are not always failing in the area either. So that's my remarks.
All right. Great. Thanks, Branislav. I think, I'm an international commuter these days, intercontinental commuter. So I fly between Sweden and California. See, it's interesting with startups, which is what you focus on as well, is that in Sweden, almost all the innovation system activity is top down. There's an innovation agency. Every company gets soft loans from the government. It's absolutely impossible for a small company to be created without interacting with the government. when I land in California, I never talk to the government. UC Berkeley produces the most startups of any university in the United States right now, all bottom up. I wouldn't even give credit to the university completely. I mean, as you guys know, the university is a feudal kingdom with a bureaucracy on top of it, right? So, but there's a lot of smart people there. And when you have a bottom-up infrastructure, you get these people together that produces a lot of benefit. So it is a bit of a dueling models of should you produce the conditions and let it grow bottom-up, or should you be top-down, and how much should you do of each, which goes back to Miguel's question of what should be the role of government in these activities. We can talk more about it. All right, let me give a quick rundown of the 6 concrete proposals that come, and then we'll talk a little bit more about that from each of the panelists. So there are 6 proposals in the Constitution of Innovation. The first one is on abandoned directives. So the argument is that they betray the harmonizing purpose. Too often member states shirk their duty to transpose directives. Their usage is suggested to be reduced, and because businesses end up facing 27 different versions of supposedly common rules. That's the first one. The specialized commercial courts. To give an example, when Italian regulations illegally block a French trader, the company faces only bad options: file a complaint with the commission and wait years for action that may never come, sue before the Italian courts that are only slightly familiar with EU law, operate illegally and hope to reach the European Court of Justice through proceedings brought against it, or simply give up. We propose that the European Union create regional commercial courts with exclusive jurisdiction over internal market violations by the member states. The Unified Patent Court is a good example of that nowadays. Federal automatic field preemption. So according to the Draghi report, there's over 270 digital regulators in the European Union, each interpreting common rules individually. The solution is that when the European Union regulates in areas of exclusive competence and internal market legislation, all national, regional, and local rules in that specific area cease to apply. This is the so-called automatic field preemption. We've mentioned this already a little bit so far, a 28th regime. It needs to be fully supranational with no appeal to national laws. A set of rules that such companies voluntarily prefer it. The incorporation, as well as the entire legal life cycle from formation to dissolution, should be fully digital. To avoid the fate of previous efforts, it should contain provisions on employee involvement. So if you want to make a real 28th regime, you need to include labor, you need to include bankruptcy, tax. I think you have to go as far as people with capital are willing to invest because something different has happened. If that hasn't happened, you haven't gone far enough. The 5th is relying on existing institutions. It is a fact that much of the European Union's expansion has taken place in areas where existing institutions already operate. Fundamental rights is an obvious example. The European Court of Human Rights, also known as the Strasbourg Court, is an international court of the Council of Europe, which has countries such as the UK or Switzerland as members. So as much as possible, don't duplicate things that are already out there. And number 6, to reform legislative practice. Once adopted, European Union law becomes the eternal law, typically nowadays. It cannot be written off, even if wrong. Of course, most, if not all, European Union regulations or directives contain some review clause, but many temporary law and policy programs have become permanent. So new regulatory structures entrench interests and are hard to dismantle. So to solve this, review clauses should be replaced with sunset clauses, where things go away. That's one way to get to less over time. All right, so these are the 6 concrete proposals. So I'd like to hear some comments on some of these. And Miguel, I know you might have to run to your celebration, so I'll start with you.
Thank you. So I chose 2 of them. and two with which I actually agree, at least one of them fully, the other one in part, and I'll explain why. And basically, I'll be brief because I'm more interested in hearing possible answers and solutions to the issues that I want to raise with respect to these two proposals, with which I am, as I said before already, overall in agreement. And the first one is the creation of the 28th regime. I'm also a believer that this could be a solution to overcome the fragmentation between member states, and also precisely the political difficulty of getting member states to agree on harmonized regimes for companies, for example, as the declaration discusses, and that has been discussed for a long period of time. I have one crucial question with respect to the 28th regime. That is a difficulty that I see. That is, who will enforce? That is, who is the administration? I mean, it's not only the enforceability of these rules is not only of a 28th regime, does not depend simply on courts. For that, a solution is put forward that is linked to this creation of these specialized commercial courts. But you need an administration that monitors a lot of these aspects of the compliance with the regime and takes whatever administrative steps are necessary in terms of the enforcement of these rules or authorizations, even if they are ex post or digitally take place digitally. This requires an administration. I don't see the EU administration as being in a position to be able to do it. The EU simply doesn't have the administration for that. And I fear the consequences of giving to national administrations the role of enforcing and applying this EU regime at the same time that they are applying a different national regime. So that's the open question and the doubt that I have on how this will work out. And I'm interested in getting your answer on how you see this happening. The other thing that is mentioned, it's recognized in the declaration itself, is that whenever the European Union regulates, and many times it's the Union intervenes to harmonize national laws with the idea of making it easier, and it ends up creating a higher regulatory burden because of the way the dynamics of the EU legislative process and decision-making process take place. So I think it will be very important that this 28th regime will be, I mean, it's crucial that is validated by an analysis whereby the information and transaction costs that it will involve will have, whatever the ultimate regulatory format chosen, always to be lower than the status quo in the member states. And that analysis needs to be done. And that's where I would link that to the sixth proposal, or one aspect of the sixth proposal in the declaration that regards the reform of the legislative practice. In respect to the reform of legislative practice, the focus is on sunset clauses, but there's something else there that I believe is particularly important, and that could be used, for example, in that kind of analysis of the 28th regime. That is the creation of an independent team of experts. I mean, it could be an independent agency that to make impact assessments of new laws. I think that if we are to take seriously impact assessments, and particularly the burden they impose on companies and the cost-benefit analysis regarding, for example, information and transaction costs that they may or not create or eliminate, it is crucial that the process of impact assessment be moved to an independent agency. Here you call it an independent team of experts. So I wanted to support that very much, and to say that perhaps you should defend that as an independent proposal from the sunset clauses. This is not to say that I don't dislike the idea of the sunset clauses. I like it too, but I think that it's much harder to apply than the declaration seems to assume. And I don't mean only in political terms. That will be hard in many cases for it to be politically adopted. I think to adopt a policy across the board that all legislation has sunset clauses brings a lot of questions and problems that may create more uncertainty than the uncertainty that they were supposed to reduce, or the regulatory burden they are supposed to reduce. Let me just make one question. So, if we have a sunset clause, when that sunset clause expires, we return to which status quo? The national status quo in that area, and companies, for example, become subject to whatever national law of the jurisdiction that they are. What's the status quo, or does it mean no regulation whatsoever in that area? I think there's a lot of questions that are not answered in that respect on how an overall principle that every legislation will have sunset clauses. I mean, I see it how difficult to operate. Think even about the 28th regime. Will the 28th regime then also be subject to a sunset clause? That will mean that in some years, if there will be no political consensus to re-adopt the 28th regime, that suddenly those companies will have no regime to which they will be subject, or they will go back to national jurisdictions. So I see it harder to apply. I like the idea. There are areas where myself has advocated for creating legislation with sunset clauses. I think more use should be done of sunset clauses, but the idea of a general principle of sunset clauses, I see it as hard to be applicable in practice. And final point, I think that if we were to create that general principle of sunset clauses, it may make the adoption of initial legislation much harder in some cases. And of course, you may say, well, that may be good because it may mean less regulation, but it may not mean less regulation if that EU legislation could simplify what is a web of national regulations. And you yourself, in the proposals, when you advocate moving from directives to regulations, something I also support, and I think it's a good idea, indicate that not always EU legislation replacing national legislation is a bad thing. Thank you.
All right, thanks a lot, Miguel. One clear way that sunsets could be good is in the area that I work a lot with patents, for example, where there's a unitary patent, but there's the old system in parallel.
I want to stress that
I would like to see the old system go away at some point.
Yeah, I'm not opposed to sunset clauses. If you identify specific areas where sunset clauses could be applicable, I think that will be more feasible. What I think will be very complicated is to have an overall principle that all EU legislation will be subject to sunset clauses.
Sure. Yeah, that's good. Fair enough. Okay. Let me go to Lorenzo, and then we'll let Branislav finish us off.
Thank you. I need the clicker. Yes, on this issue about the sunset clause, I think, Miguel, you're raising very very valid questions and concerns, and I fully agree with you. I would not, go by default to sunset clause. Eventually, at best, they will turn into review clause, and that is something that is manageable and actually desirable. But otherwise, it might create a legal vacuum. So in that respect, all the remarks that you made, I think I totally agree with you. My focus of these or the 6 proposals is especially on the first one, touching upon the 6th as well. So the first one is about abandoning recourse to adopting directives and going for regulations. And we know the reasons. You have highlighted them. Directives contribute to the fragmentation. We have the gold plating problem. We have also poor capacities in national capitals to transpose properly according to good regulatory principles and tools. Much less capacity than, or fewer capacities than what we have at the EU level, to be frank, on average. The declaration highlights the weaker enforcement commitment or rigor by the Commission, because it is a political commission. That's clear. But going full into regulation-only mode it's a good idea, but we have to take it to make it workable, we have to consider its natural consequences. And the natural consequence is that the regulation doesn't stop, obviously, when it is adopted. We have something following that, and what follows or what comes afterwards is what we can call the EU administrative state. And what is the EU administrative state? It's a web of legal arrangements, legal instruments implementing delegated acts, decisions, etc., soft law, guidelines, and institutions. We have EU agencies, we have scientific committees, we have technical working groups. And this administrative state is actually at the core of risk assessment and risk management decision as well, in virtually all sectors involving technology, involving innovation. And it's also where de facto eventually the rubber hits the road. So where we have tangible impacts on businesses and on consumers. And as a matter of fact, it's something that is not really governed properly in a centralized way. There are good practices in it. There are also pockets of excellence in it. A sector that I think works fairly well, it's cosmetics, fragrances. It's not by chance that those industries see European companies in the lead globally, Givaudan, Givenchy, Firmenich, and others, L'Oréal. But as a matter of fact, sorry, does it click? I don't, okay. There are a number of challenges overall. One is that this administrative state has grown without a strategy, without a plan. Each regulatory regime has created its own governance, and that's a problem. And the second challenge is that the current better regulation agenda, the current system set up by the Commission, very much considers the legislative procedure, the ordinary legislative procedure, doesn't enter into the details of the functioning of the administrative state. Take public consultation. Public consultation, you don't have a clear, transparent minimum period for consultation, as you have for ordinary legislative procedures. You don't know exactly who is participating in this consultation, in the various working groups, in the various stock taking that they are organized. Take, for instance, regulatory science. What is the definition of best available science? When is it applied? It's the criteria for understanding what it is vary from one agency or one technical working group to the other. Sometimes also legal or policy documents refer to the latest or the most relevant evidence, not necessarily the best available one. Impact assessments. It's true there are problems with impact assessment, application of cost-benefit analysis and other economic analysis regulation throughout the ordinary legislative procedures. This is the point made in Proposal 6. It should be a living document, the impact assessment, but we have really even less understanding of what's going on in the administrative state. I'll give you a very quick example. Just a couple of weeks ago, ECHA, the European Chemicals Agency, has endorsed an opinion, and is open for public consultation now, on the total ban of PFAS, the famous or infamous forever chemicals, right? These are substances that are very persistent in nature. They are also cumulative, etc. So they are there, and once they are released in the environment or in our bodies, they stay there. And the RAC, under the REACH, the Chemicals Regulation, the RAC, which is the Risk Assessment Committee, from a scientific point of view, has issued an opinion recommending total ban. And at the same, under the same regulation, REACH, you have SEAC, which is the Social and Economic Assessment Committee that is supposed to look into the proportionality of the measures to recommend to the European Commission. And SEAC has endorsed the opinion of RAC, but from a proportionality point of view, so they carry out an impact assessment, apparently. They says, no, a total ban is too much. Let's go for a total ban with derogations. Again, the issue of derogation. But the key point is that they acknowledge in their opinion, and it's all public, so you can look at it, not only that they have doubt about the proportionality of the measure, but they struggled to establish the proportionality because there are no data. There are no data to actually see the benefits of a total ban because it's all encompassing and it's across all sectors, and we don't know who is going to be affected down to the value or supply chains. So this is the type of analysis that are totally untransparent in the sense that they are there, but how can we deal with those? I will accelerate. So what is the, if I were to choose one solution or one proposal to further complement your proposal in the declaration, is to make due process standards legally enforceable. And the idea is here to mimic what the United States you have as with the Administrative Procedure Act, well, the creation of EU law on administrative procedure. You have this type of instruments in the majority of the member states, not at EU level. And there has been an effort done some 10 years ago. We worked with the European Parliament to push for that. The European Commission has always resisted. But I think it's one way to constrain the liberty, the discretion in applying good regulatory practices in the implementing phase of regulation of the regulations is to go with judicial review. Thank you.
All right, thank you, Lorenzo. Please, Branislav.
Thanks a lot. No, I don't want to stand between you and the lunch, so I will try to be quick. Well, even more importantly. So just very quickly, I also selected basically two measures, but actually I'll mainly talk about very quickly about the 28 regime, because reading about the 28 regime in the paper, I was like, well, now we have the 28 regime, so why not to market it? So, but do we really? I believe we do. But through that, I will also touch upon some of the other proposals that were made in the declaration. So we have the 28 regime now, or we have a proposal for the 28 regime, more correctly stated, that the council now said they have an ambition to make it into an actual law by the end of the year. So there is a willingness and push from the side of the member states to get this adopted rather quickly, which is a positive message. And we have the 28 regime that we believe that that's what the companies basically ask for. So it's also quite a unique example of almost a grassroots initiative that reached the corridors of the Commission and was actually turned into the law. So what does the 28 regime deliver? It delivers, as also called by the paper, comprehensive optional EU-wide company legal form that is attractive, hopefully, to all companies operating and scaling up across the single market. And it basically covers the entire operation of the company. So starting with the establishment, it provides for the establishment in any member state under this recognized legal form, a new legal form of EU Inc. within 48 hours with the maximum costs of 100 euros for all the ex ante checks and procedures. It removes things like apostille requirements, so really reduces the amount of bureaucracy that the companies have to do. Fully digital establishment through a single EU portal. Okay, still registered in member states because EU itself is not the state, so you need to register somewhere your company. So you'll still register in a member state of choice, but through a single regime, using templates, for instance. Also, again, reducing or harmonized templates, reducing the amount of burden and reducing the amount of diversity in these kind of procedures. And then you move to the company operation. So financing is an important part. There very flexible share structures allowed under the 28 regime. Basically, companies can by the way, they don't need any initial capital, but then they can issue all sorts of shares, different voting rights, also helping them to prevent things like hostile takeovers, especially in the early stages. So and once again, very digitalized. So the entire 20 regime is fully digital, making use of the existing tools, interconnectedness of the registers under the BRIS, which is an existing tool that connects all the company registers in the EU, making use of the new EU digital wallets, where you can exchange documents between yourself as a company and the various authorities, indeed making your life as a company easy throughout the process. But what if you fail? Then you have also simplified insolvency procedures for startups, particularly because, again, as we discussed, these are the most vulnerable ones, and the idea is that they have to restart quickly, or to help them restart quickly to the founders and go to the next venture. But also you have generally simplified winding down procedures for all the 28 regime companies. Again, fully digital, using of online auctions, etc., etc. On top of that, the regime also introduces the EU-wide employee stock options plan that the companies can make use of, where they can issue employee stock options to attract talent. Again, the attractive thing about this is that it not only allows all of the companies to do that, it also sets the point of taxation for the income that is basically generated by the employees once they exercise the stock option. And this was a problem because it was different everywhere in Europe. Now it's at the point of sale. When you earn the money as an employee from selling your stock, then you are taxed. So all of this to help basically also companies to attract talent, especially small ones, when they cannot pay you upfront very high salaries. So just to show that really the 28 regime is hopefully soon will be the reality. Of course, it doesn't cover some things. It doesn't, for instance, cover labor. That it leaves it to the member states, employee participation as well. But this is also something that the Commission was actually listening to the ecosystem and to the community, because the community, when startups came to us, they were very much asking, go small and be rather targeted. So don't do what they say, the usual Commission thing, that you try to overregulate everything, but really do something realistic that is going to help us on the day-to-day operations, which I believe the Commission has delivered in terms of the proposal. And that also links to the form of the 28 regime, and there's another part of the proposal, which is it's in the form of regulation, indeed, to prevent gold plating and ending up with 28 regimes in the EU. But what I also need to say, that's going away from the 28 regime, but a bit on this split between regulations, directives. Of course, directives still remain, and we need to be realistic, they will remain part of the EU acquis, because simply they are EU acts under Article 288 of the treaty. And you have many legal bases, by the way, also related to single market, like taxation, that simply only require directives. So there, I think we need to be realistic that we will continue having directives. And then Commission does, or I mean, many of the directives, especially the new ones, they go the direction of maximum harmonization, where you have a very little steering on the side of the member states, and it's essentially almost behaves like a regulation. Good example is the public procurement, for instance. And then finally, just very quickly on the better regulation, because this is also a fascinating area. I mean, I'm not at all an expert. Well, now a bit through our work on the Innovation Act, we had our own experience with better regulation and impact assessment. But just to say that of course one thing is impact assessing on the side of the Union, and I think here Commission, okay, having some sort of, there are still some defaults in the better regulation guidelines, of course, but it's almost the state of the art what is currently being done when it comes to better regulation. But what we heard from many startups when we consulted them both on the strategy and on the Innovation Act is that often the law blocking innovation is not the EU law, it's the national law, and there's probably a lot of work to be done at the national and member state level to also follow some sort of impact assessment, ex-ante assessment on innovation, cost benefit, etc., before member states adopt their own laws. I mean, the work on the innovation principle is extremely important, as mentioned by Lorenzo, but also, and my last point on the regulatory sandboxes. We often tend to market them only as a tool for innovators to test their innovations in the real world conditions with some derogations. But actually, regulatory sandboxes also fulfill another important role, and that is of the regulatory learning, which basically enables the authorities to test the existing laws vis-a-vis the new type of technologies, new innovations, and ideally take lessons learned and reflect them in the future revisions. So regulatory sandboxes as a tool, both ways, testing innovation, but also testing legislation. And that's why we'll market my own file. We are looking at regulatory sandboxes also in the context of the European Innovation Act. And hopefully the idea is to bring a level of harmonization on how the regulatory sandboxes are done across the EU, how they are actually defined in the first place, how to establish them, how to oversee them, and how to take the best out of them. Thank you.
All right, thanks a lot. So as a how you say, as a good faith offer, my suggestion is that the European Parliament stop moving the Parliament to Strasbourg every month, because if they can't stop doing that, it's hard to believe they can accomplish more, because it's completely unnecessary. If bombs were falling in Brussels, I doubt they would get on the train and go to Strasbourg, and that's what Draghi means by existential. So we need like an Operation Warp Speed thinking in Europe. And I wonder that we have too many lawyers, not enough engineers, which is one reason why China is doing so well now on one side of the... So any questions on the future and the fate of Europe? Yes, Pierre. Is it on?
So on. But at the end, at least it's the first go. It just adds layers and more institution. As you pointed out yourself, do you think the other institution is just you're going to die and disappear? You've got to clean up house. You know, if you do all this kind of stuff, there's going to be way too many people in the commission. Do you think those people are going to go willingly? No, they find things to do. There is work for idle hands. And if we do not address this, all the more the great plan and ideas that we spew here, well, it's just going to be useless and actually could be counterproductive. How do we address that?
There's a lot of people peddling bicycles. Question. That's good to have. Other question? Take some comments.
Okay.
Here we go. So I'm going to start with a question to you, Bo. How do you know what to do? Like when you wake up in the morning, like how do you know what you need to do to perform well in your job? Because there's an entire EU institution devoted to figuring out what people need to do to perform in their jobs. I only discovered this recently because we are building an online training program for hotels. But there's an entire institution in Thessaloniki which is building job profiles. So they will have a job profile for professor. It's like, as a professor, you need to have these capabilities, and these are the tasks you need to be able to perform. If you're an engineer in chemical engineering, this is what you need to do. There are hundreds of job profiles that no one ever uses. I think that's exactly to Pierre's point. Like, we have institutions which serve no purpose. I mean, there might be one purpose, regional development. I mean, you know, but otherwise, like, there's just it doesn't create any impact on the ground. Like, yeah, they also do some research, but it's largely duplicative of what member states already do. So I think that's exactly what we need to do. We need to clean up the house. We need to look at the purpose of each and every institution and think about, like, is this really needed at the EU level? Is there a value add to this?
Very good. So stop cycling and renovate the house. That is our house analogy. Please, comments?
So just very quickly on again, beyond my expertise in innovation policy, but just a quick note. I mean, my impression is, being in the Commission, is we are going the other way around. I mean, you see the amount of policies, you know, Commission is not inventing its own policies very often. We are being asked by the member states, do this, do that, do that. So very often, actually, the growth of the amount of responsibilities comes because there is a political order from the member states. And I mean, I can tell you quite frankly on the staffing side that the problem is the other way around. We would need ideally more people because the burnout rates are going higher.
You have to say no.
Right, I have trouble with my clicking, sorry. Yes, I think they are very pertinent questions, and in a way it's inevitable that a public administration tends to create, to perpetuate itself, or even, you know, by osmosis, create doubles. But the question is not only about the number of institutions of what they do, but also the people. And I try to bridge the two comments, the competencies of who is sitting there. And I think I mentioned the example of the cosmetics or fragrances regulatory framework. And why is that a good practice to follow? Well, a lot of the scientific work carried out in approval of those technologies and substances is done by the SCCS, which is the Scientific Committee of Consumer Safety. And that committee differs from other committees that take on the same functions in other regulatory regimes, like, for instance, pharmaceuticals or others. They are technical working groups. Now, what is not the name that matters, but is the origin of it. As you know, these comitology systems, so these systems of implementing EU legislation, have been designed on the model of, for instance, common agricultural policy, where it was a means for the member states to keep control of what was decided at the EU level by the Commission in technical discussions. So who are the members of these committees? They are delegates from national administrations. This is a technical working group model. The SCCS is different. The SCCS is not the sum, so it's not 27 scientists from each of the member states. It's a selected premium of supposedly top-notch scientists. So when they come up with regulatory science reviews and decisions, chances are that all of them know what they're talking about. With all due respect, but in some technical working groups, you have members that are sitting there and it's not their field of expertise. But in a public administration like Malta or Cyprus or so on, you do not have, you know, the expert in, you know, surface chemicals or coating or so on. So that is a big issue. And it's part of the administrative state design that I was referring to.
Thank you, Bo. So a couple of months ago, we organized an event here on the Constitution of Innovation with Luis, and I was there. We invited a former commissioner, Commissioner Erkki Liikanen, Finnish commissioner. He was a commissioner for monetary affairs or something like this. He told us a story that was very interesting. He said, when I took my job in the first commission, I think it was in the Center Commission, he asked Jacques Santerre, he said, what's the role of the commission? What should we do? And Santerre, I don't know if it's Santerre, but it's a president of the commission, said the commission has two roles, guardian of the treaties and legislation. Okay. And then he said, the next commissioner came, Prodi, next commissioner came, Barroso, next commissioner came Juncker. Commission must be more political. That's 15 years ago, something like this. Juncker decided the commission should be more political. This led, according to Erkki, to a complete marginalization of the enforcement guardian of the treaty role. The commission became just a political animal designed to pass legislation for the sake of it. The KPI of the commission is to put legislation in the hands of the council and the parliament. The commission has become a broker for legislation. This is what the commission does. And the only KPI that matters is increasing the amount of legislation. Anything that stands in the way, better regulation, impact assessments, sunset clauses, is a cost that weighs down on that KPI. The incentive structure of a political union is wrong. Gian Domenico Maggione, professor here in the past, a good friend of European integration, a pope of the European Union, wrote a paper a couple of years ago called Crypto Federalism. He writes, I'm going to quote, the EU lacks a systematic evaluation of the effectiveness of the measures undertaken. And this applies across the board. So there's a simple solution for the EU to find its direction. It's to abandon this fetish of political integration in favor of what Maggione called European integration, economic integration. And the first tool that the Commission can deploy, that's not less, actually that's more, is to actually actively litigate against member states, against legislation, local, regional, national, that stifles the internal market. It cannot do that if it's a broker in legislation, because it needs the support of the member states in the council to pass legislation. So there's a huge conflict of interest. The system cannot work this way. So this probably implies changing the mind, not actually firing bureaucrats in Brussels, but telling them, stop with the Innovation Act. Stop with the Cybersecurity Act. Stop with the DMA, the DSA, the DPA, the DTA, the DZA. Stop all this. Just enforce the basic prohibitions that we find in the treaty. I think that will make a huge change in the amount of productivity we get at the end of the system.
All right, I think there could be a lot of comments to that, but I think we'll let him drop the mic on that one, that ending, and we'll move to the next. So please join me in thanking our panel.